Your home is your castle, or so you thought. But what if I told you that the Supreme Court just made a decision that could change everything you believe about your right to privacy? In a shocking 9-0 unanimous ruling, the highest court in the land just redefined when police can burst through your door without a warrant. And here's the kicker. Every single justice, from the most conservative to the most liberal, agreed on this. When was the last time you saw that happen? This isn't just another legal case that'll collect dust in some law library. This is about your front door, your living room, your bedroom, the places where you should feel safest. And if you own firearms, well, you need to pay extra close attention because what I'm about to share could directly impact how secure those possessions really are in your own home. The case that sparked this seismic shift is called Case versus Montana, and the story behind it reads like something out of a thriller novel. It all started with a phone call that would end with a man being shot in his own closet by police who entered without a warrant. But here's where it gets really interesting. The Supreme Court says they were right to do it. Let me take you back to where this all began. Trevor Case's ex-girlfriend picked up her phone one night with a sinking feeling in her stomach. She'd just gotten off a call with Trevor, and something felt terribly wrong. She couldn't quite put her finger on what he'd said exactly, but she remembered hearing something about a gun. Maybe he mentioned harming himself. Maybe he mentioned the police. The details were fuzzy, but that gut feeling, that was crystal clear. So she did what many people would do. She called the police. And when 4 officers showed up at Trevor's house, she was there with them, still trying to piece together exactly what he'd said on that phone call. The officers knew Trevor. They'd dealt with him before. They knew about his mental health struggles. This wasn't their first rodeo with him, and that history made them extra cautious. Now here's where the tension really starts to build. The officers arrived at a dark house, no lights on, no movement inside. They started doing what any concerned person might do. They knocked on doors, called out Trevor's name, shined their flashlights through windows. Nothing. Complete silence. But then one officer spotted something through a window that made everyone's blood run cold. There on a table sat an empty gun holster. Right next to it, a notepad. The gun that should have been in that holster, nowhere to be seen. For 40 long minutes, these officers stood outside that house. 40 minutes of knocking, calling, waiting. 40 minutes of growing dread. Some of the officers were getting nervous. They'd dealt with Trevor before. They knew this could go sideways fast. But after those 40 minutes ticked by, they made a decision that would eventually land this case in front of the Supreme Court. They tried the front door. It was unlocked, and they went in. 2 officers headed upstairs while others secured the lower level. One officer pushed open a bedroom door, scanning the room for any sign of Trevor. That's when he noticed the closet. More specifically, he noticed the curtain covering the closet suddenly jerked to one side, and there was Trevor hiding inside. What happened next took mere seconds, but would have consequences lasting years. The officer saw something dark in Trevor's hand. In that split second of recognition and fear, the officer fired. The bullet struck Trevor in the arm and passed through into his stomach. When the dust settled and Trevor was in custody, officers found a handgun in a laundry basket in that same bedroom. Trevor survived his injuries, but he wasn't about to let this go. He fought back the only way he could, through the courts. His argument was simple but powerful. The police had no warrant to enter his home. Everything they found, including that gun, should be thrown out as evidence because they violated his Fourth Amendment rights. The lower courts didn't buy it. Neither did the Montana Supreme Court, though they came to their conclusion in a way that would ultimately catch the attention of the U.S. Supreme Court. You see, the Montana court used something called a reasonable suspicion standard to justify the officer's entry. But there was a problem with that approach, and it was about to become a very big problem for how we understand our rights.
What's it take for an officer to determine there's an emergency and then enter into your home without a search warrant?
As we all know, that searches require, under the Fourth Amendment, a warrant.
Every time cops kick in someone's door to help them, how sure do they have to be that you actually need help?
How do courts determine whether or not the use of force is objectively reasonable?
The Supreme Court is set to hear oral arguments in a case that could impact what's needed for law enforcement to enter your home without a search warrant.
The 9-0 case that relates to Fourth Amendment rights. We've heard from Edwin, they're kicking the guts out of the Fourth Amendment. Well,
the U.S. Supreme Court had already dealt with similar situations before in a case called Brigham City versus Stewart. In that case, they'd established a specific test for when police can enter a home without a warrant during emergencies. It wasn't about probable cause like in criminal investigations. It wasn't about reasonable suspicion either. It was about whether officers had an objectively reasonable basis to believe someone inside was seriously injured or facing imminent harm. Montana's court had used the wrong playbook, and that gave Trevor Case his shot at the Supreme Court.
Case versus Montana deals with the emergency aid doctrine.
Shocker, they haven't changed the trajectory of their decisions, but it could have big implications for gun owners.
Constitutional protections of your home are absolute.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
A handful of courts are saying, you know what, the police need probable cause to enter without a warrant, even under these kind of exigent circumstances.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
A constitutional standard for police behavior throughout the entire United States.
When the highest court in the land agreed to hear his case, legal experts started paying very close attention. This wasn't just about Trevor anymore. This was about drawing the line between public safety and private rights for all Americans. During oral arguments, the justices grilled both sides. They wanted to know exactly where the boundaries should be. How much evidence do police need before they can break down your door in an emergency? What counts as an emergency anyway? And perhaps most importantly, who gets to make that call in the heat of the moment? The Supreme Court had two paths they could take. They could send the case back to Montana and tell them to do their homework properly this time, using the right legal standard. Or they could tackle it themselves, applying their Brigham City precedent to Trevor's situation and giving lower courts across the country clear guidance on how to handle these scenarios. In a move that surprised no one who'd been following the oral arguments, they chose door number 2, and in an opinion written by Justice Ketanji Brown Jackson, all 9 justices agreed. The police were justified in entering Trevor Case's home that night.
Shot by police during a welfare check, convicted of assault for holding a gun in his own home that the cops entered without a warrant.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
Deadly force is only authorized if the officer has probable cause to believe that the suspect represents an immediate threat.
This was a majority opinion by Kagan, but it's a 9-0 decision. And so, everybody kind of is agreeing on this point.
Officers need that some sort of emergency is afoot before they can enter into somebody's house without a warrant.
But here's the crucial part that everyone needs to understand. The court didn't say police need probable cause to enter your home in an emergency. That's the standard for criminal investigations, and the court said it doesn't fit well with life-saving situations. They also rejected Montana's looser reasonable suspicion standard. Instead, they reinforced their middle ground approach. Officers need an objectively reasonable basis to believe someone inside is seriously injured or about to be. Think about what that means in practical terms. If someone calls 911 saying they heard gunshots from your house, police don't need to wait for a warrant. If your ex calls saying you sounded suicidal on the phone and mentioned having a gun, they don't need probable cause that you've committed a crime. They just need an objectively reasonable basis to think you might be in danger.
Loophole the police are using to get inside your home without a warrant.
And it's a case that could redefine what's needed for police to enter your home without a search warrant.
It said in part that gun regulations must be consistent with the historical tradition of firearms regulations in the U.S.
A case where the court was asked to decide if the same warrant exception that applies to impounded vehicles applies to homes.
Something that hasn't been used a lot, and the court had to address whether it can be used at all when it involves a home.
Not having this Fourth Amendment to protect you and protect yourself from the police just entering your home without a warrant, that's pretty crazy.
The court looked at all the facts in Trevor's case, the concerning phone call, his history of mental health issues, the empty holster visible through the window, and 40 minutes of no response, and concluded the officers were objectively reasonable in their decision to enter. As Justice Jackson wrote for the unanimous court, the Fourth Amendment does not require police to stand idly by in the face of imminent danger to human life. Now, you might be thinking this sounds reasonable. After all, if someone's life is genuinely in danger, shouldn't police be able to help? But here's where it gets complicated. Who decides what's objectively reasonable? In the heat of the moment, it's the officers on scene. After the fact, it's the courts, and that leaves a lot of room for interpretation. For gun owners, this ruling carries special weight. The The court has now clearly stated that concerns about firearms, combined with other factors suggesting someone might harm themselves or others, can justify warrantless entry.
There's a myriad of things that can tie you up legally, financially, put you in jail, or maybe get you in very serious trouble with the police.
Even if you are innocent, your words can still be twisted and taken out of context.
And the question is, what should be legally considered when deciding if an officer's use of force is justified?
There's a circumstance where, all right, exigent, no time to go get a warrant. So we need to act right then without delay.
Montana Supreme Court upheld the denial, and which didn't go well for Case, obviously, so he appealed to the Supreme Court.
Once police are lawfully inside your home, even without a warrant, anything they see in plain view can potentially be used as evidence against you. This isn't a partisan issue either. Remember, this was a unanimous decision. Every justice, regardless of their judicial philosophy, agreed that emergency aid situations require a different approach than criminal investigations. They all signed on to the idea that saving lives trumps the usual warrant requirement as long as officers meet that objectively reasonable standard. The ripple effects of this decision are already starting to spread. Lower courts across the country now have clear marching orders on how to evaluate these emergency entry cases. Police departments will likely update their training to reflect this standard, and defense attorneys will need to adjust their strategies when challenging warrantless entries. But perhaps the biggest impact will be on how we, as citizens, understand our rights.
The public is demanding of its public officials that we take action.
Gun owners should ignore.
And I think it's pretty simple, is that we want to do our due diligence if we're looking to give people gun rights.
The Supreme Court just came down with its biggest Second Amendment ruling in more than a decade.
And the emergency aid doctrine tells us that officers are reasonable when they make a warrantless entry into the home.
Because these cops think you need help, or based on information, unverifiable information.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
Your home is still your castle, but the drawbridge can be lowered without your permission if authorities have an objectively reasonable basis to believe someone inside needs immediate help. It's a balance between privacy and public safety that the Supreme Court has now definitively tilted toward allowing intervention in genuine emergencies. This ruling serves as a reminder that constitutional rights, while fundamental, aren't absolute. They exist in tension with other important values like preserving human life. The Supreme Court's job is to balance these competing interests, and in Case versus Montana, they've drawn a clear line. When there's an objectively reasonable basis to believe someone's life or safety is at risk, the sanctity of the home must yield to the imperative of emergency aid. Whether you agree with this balance or not, one thing is certain: this decision will shape how police interact with citizens in emergency situations for years to come. It's a ruling that every American should understand, because it directly affects one of our most basic expectations of privacy, the security of our own homes.
This is when we talk about, hey, you know, invoking your rights, or they didn't read me my rights, or they searched me without a warrant.
Is probable cause the legal standard to rely on the emergency aid doctrine?
Once the police are in your home, if they see something that catches their eye, you know, they can always say, oh, well, we walked back out and then we got a warrant for whatever we wanted.
He appealed, arguing the cops violated his Fourth Amendment rights because they didn't have a warrant. And last week, the Supreme Court weighed in.
With gun control being implemented in a number of states, even where least expected, this is not a bill that...
The unanimous nature of this decision sends a powerful message. In an era of deep judicial divides, all 9 justices came together to say that emergency aid situations demand flexibility and Fourth Amendment protections. They've rejected both extremes, neither requiring full probable cause nor accepting mere hunches, and settled on a standard that aims to protect both lives and rights. As we move forward, the real test will be how this standard is applied on the ground. Will officers use this ruling responsibly, entering homes only in genuine emergencies? Or will we see an expansion of what counts as an emergency that justifies warrantless entry? Only time will tell, but one thing is clear: the Supreme Court has spoken, and they've spoken with one voice. This case reminds us that our rights exist in a complex ecosystem of competing values and practical realities. The Fourth Amendment's protection against unreasonable searches and seizures remains robust, but it must bend when human life hangs in the balance. It's a trade-off that the Supreme Court believes is not just acceptable, but necessary in a civilized society. For now, Americans must grapple with this new reality. Your home remains protected by the Fourth Amendment, but that protection has clearly defined limits. when emergency aid is at stake. Understanding these limits isn't just important for lawyers and law enforcement. It's crucial for every citizen who values both their privacy and their community's safety. That's it for today, folks. See you in the next video.